The United Nations has moved to recognize the transatlantic trafficking and racialized chattel enslavement of Africans as the greatest crime against humanity, and the United States voted no. This vote by the United States carries a legal meaning. It doesn't dispute that slavery was wrong. Instead, its position is that there is no legal right to reparations for historical wrongs that were not considered illegal under international law at the time they occurred. This posture by the United States does not exist in isolation. In fact, it reflects how American law has treated Black people since the beginning. Slavery in the United States was not an aberration. It was a legal system. Human beings were considered property, and that classification was enforced by statutes, constitutions, and the courts. Even after the abolition of slavery, the United States did not get rid of that system. Instead, it just reorganized it. The 13th Amendment to the Constitution eliminated slavery but preserved forced labor as punishment for crime. Systems of criminalization, segregation, disenfranchisement, and economic exclusion followed, and each of those were grounded in law. Recognizing the transatlantic slave trade as a legal wrong of the highest order carries consequences. It places weight on the idea that harm did not end with abolition, and it frames the conditions that followed as part of a longer legal structure. And once that structure is acknowledged, the question inevitably shifts to what the law requires in response to that wrong. And that is where the United States drew the line. Giving legal force to that acknowledgement does not stay confined to the past. It carries into present-day systems, housing, property, criminal law, labor, voting, and it raises questions about how those systems were built, how they operate, and whether they could stand in their current form without addressing the harm they carry forward. That is the context behind the United States' vote. And to understand it, we have to examine how American law has constructed, preserved, and adapted systems of inequality over time, and what it would mean to formally recognize that continuity in legal terms. The law did not move from slavery to neutrality. Instead, it moved throughout a series of legal frameworks that preserved inequality in different forms across time. After slavery was abolished, states enacted black codes that criminalized ordinary conduct and dramatically expanded arrests and detentions. Systems such as convict leasing and chain gangs developed alongside these laws. So even though forced labor was officially abolished with the 13th Amendment, it continued to expand and proliferate across the country, just under a different legal framework. Segregation laws formalized racial separation in public life. Voting restrictions limited political participation. Property regimes, such as redlining and racial restrictive covenants, dictated where Black people could live and build wealth. Education and employment were governed by systems that excluded or subordinated Black people, often with legal support and tolerance. This history is not separate from the present. The systems that govern voting, labor, housing, criminal law today were built within these structures. They reflect one another, and oftentimes they continue to reproduce its effects. This is the legal context in which acknowledgement operates, and it's the legal context in which liability is still refused. The United States has, in certain contexts, recognized harm in legal terms and attached remedies to that recognition. In 1988, Congress enacted the Civil Liberties Act. The statute issued a formal apology to Japanese Americans incarcerated during World War II and provided monetary compensation for surviving internees. It expressly acknowledged that harm resulted from federal action. Claims brought by Native nations have also been addressed through legal processes, including compensation for land takings and treaty violations. Now, these processes are incomplete and contested and frankly inadequate. They do not address the full scope of harm. But nevertheless, they do reflect a framework in which certain claims have been recognized and in some instances have been provided some sort of remedy. The United States has also supported compensation efforts for victims of the Holocaust through legal and diplomatic engagement with European states and institutions. Now, these examples are not equivalent to one another, and they don't create some sort of model for repair. They differ in scope, structure, and adequacy. But they do reveal something narrower. In each instance, the law has recognized a harm in a way that has allowed some form of remedy to follow. The approach to slavery and its aftermath has been different. In 2008, the House of Representatives passed a resolution acknowledging slavery and Jim Crow as fundamental injustices, and in 2009, the Senate adopted a similar resolution. However, both included explicit language stating nothing in the resolutions could be used to support a claim against the United States or serve as a basis for liability. So both acknowledgments did recognize harm while also having a legal effect that affected that recognition. With the added context, I think it makes more sense as to how the United States arrived at its vote for the resolution proposed by Ghana. And with the vote of no, the United States has declined to acknowledge any present obligation arising from the system of slavery. And that's a legal determination. And it also is a statement about what American law is willing to carry forward and what or who it's trying to leave behind.